Hello, everyone, and welcome back to the Reinvent Legal Business Series number 2. I'm absolutely delighted to be here with a fabulous international panel, which we're going to discuss the very important topic of the new legal industry regulatory regime. As you know, we are offering these sessions as webinars and also as part of the Legalpreneurs Sandbox podcast series. So you can watch or listen as the case may be, and please do both of those and recommend this to others that would also like to watch and listen. We'd love you to do that too. I'm going to be exploring a lot of things today, but kind of on the top of the agenda are things like what the drivers for regulatory reform in the legal industry are, what the focus of that reform has been, and also that link, the important link between legal innovation and regulatory sandboxes, and of course lots more. So I'll be asking a bunch of questions of the folks that you see here on the screen. Our panelists are going to introduce themselves, in fact, in the very next couple of seconds. And so it's just for me to say initially a huge welcome to Linda, John, Jason and Jenny. Hi folks, good morning, good afternoon.
Hi.
Linda, the first question I should ask you is that you need to change your name to Jinder because everyone else is a J in this list here, right?
So I'll get right on that.
Thank you. So let me just jump in, as I said, by getting you to do a bit of an intro and a little bit about your background, but also your connection, if you could, with the kind of whole legal industry regulation phenomena, if you like. And Jenny, I thought I'd kick off in Australia and ask you that question first, and welcome.
Thank you. Thanks for having me, Terry. It's always great being a part of discussions like these. So I'm currently Manager of Innovation and Consumer Engagement at the Victorian Legal Services Commissioner, but that's one of a number of roles that I've held in legal regulation since 1994. So I started out in New South Wales as an ethics advisor and complaint investigator, and in Victoria I've been a complaint investigator, and for about 9 years I managed the front end of our complaints and inquiries section, and in the course of that read about 15,000 complaints. So I am an expert in what clients of legal services don't like.
You don't want the title of Queen of Complaints though, I imagine, right?
Oh, I love that title.
All right, that may come back to bite you, but fair enough. I thought we'd zip over the Pacific Ocean and ask you, Linda, to tell us about you.
Well, thank you, Terry, for having me. And hi, everybody, whatever time of day it is, wherever you are. I'm in Scottsdale, Arizona, and I'm an ethics lawyer. I advise law firms on ethics compliance in the U.S. for the most part. I previously was a regulator like Jenny. I was the ethics queen in Arizona. And now I do that for money for firms, and have been involved in the innovations in regulation for a number of years through the American Bar Association. I'm a past president of a national association of professional responsibility lawyers, and we've been looking at this issue for a number of years. And then most recently, in the last couple of years, yet another, as my husband likes to refer to it, non-billable project of mine. I've been helping our Arizona Supreme Court with the changes in the regulation of the profession here.
Thank you very much. I'm thinking that maybe we can get a side hustle going with you and Jenny about ethics complaints or something like that, and have dueling kind of whatever across the ocean. John, tell us all about you.
Well, thanks, Terry. It's really good to be with this group. I'm looking forward to the conversation. I'm a practicing attorney. I guess still that's first and foremost. I've been a trial lawyer out in the state of Utah for over 35 years, worked with one of the large firms in the Mountain West. But when I'm not working on my day job, I've been involved in the profession in our state as the bar president, and most recently have been leading our efforts in Utah along with my sidekick, Justice Amonis, to bring forward the idea of regulatory reform. And that's been a couple of years of writing and working. I guess in reality, I'm now a rookie regulator because I've been recently appointed as the chair of the court's innovation office, which is the office that is now running this new thing we're going to talk about, the sandbox.
Yeah, which is fantastic. I mean, we've seen innovation committees kind of emerging in some law firms, but to see that kind of starting to develop and grow within a regulatory authority or regulatory regime is fabulous to see as well. Which brings me very quickly to you, Jason, and all about you.
Hi, good to be here. My name is Jason Solomon. I'm the executive director of the Center for the Legal Profession at Stanford Law School. So we're in California between San Francisco and San Jose. I've been working as a professor, administrator at law schools for the last 15 years or so. And what the Center on the Legal Profession does is essentially education, research, policy, and advocacy into a range of issues facing the legal profession. And two at the top of the list are how we regulate legal services and access to justice and the intersection between those two issues. Our faculty director, also Deborah Rohde, is one of the world's leading legal ethics scholars. So we have a great interest in these issues and happy to be here.
Thank you very much. And again, welcome everyone. I'm going to kind of start at the beginning in this discussion. And Jason, I'm going to stay with you initially with this and kind of look at what the drivers for regulatory reform have been. And I imagine as we discuss this, we're going to see some that are common, but also some that may be specific or have been prioritised in a different way within our various states, as it were. So Jason, in California, and I guess you've somewhat already hinted at this, but what have been those big ticket items, the big drivers for regulatory reform?
Sure. I'd say there are roughly three things here in California that are driving the reform. The big one, of course, is the continued existence of a big gap in access to justice. And when we say access to justice, we're not just talking about the poorest among us, people who qualified for legal aid, but we're talking about millions of people in California who are of modest incomes, who are middle class, people who own small businesses, everyone except really wealthy individuals and big business who really can't get access to legal services on things that are very important to their life or to their business. So that's number one, and that is persisted here in California and across the country. Related, number two, is the fact that prior attempts at solving this problem just have not worked. So attempts to get more legal aid funding, attempts to get more pro bono, these have been great efforts. They have had some impact, but there's no way that they have made or can make the impact needed to address the justice gap in a meaningful way for all these individuals and small businesses in California. That's number two. And then the third thing really is, here in California, of course, we're known for we do have a lot of innovative companies. We believe in innovation. And so I think when regulators in California started hearing about states like Utah and Arizona, as we'll hear about shortly from John and Linda, who are really taking some innovative steps to provide legal services in a different way, people in California said, hey, we're innovative. Innovation is in our DNA here in California. We ought to be trying things too. And so I think that's another reason why we see California starting to move forward.
And I guess within that innovation, Jason, the other one that often kind of comes up in this discussion is tech. And I guess as we look at California again, you're kind of in tech central in a way, aren't you, in terms of that aspect of it too?
Yeah, and I think, people here, have seen both the benefits that technology can bring to folks and also some of the risks. So I think that both regulators and, just people, members of the public, understand that there should be a way to capitalize on the benefits that technology and the advances that technology can bring, while understanding the risks and doing what we need to do to mitigate those risks.
Yeah, absolutely. Thank you for that. Linda, Arizona, big drivers there for change, regulatory change? Similar, different?
Well, and I think most of our change actually started with our court. Our Chief Justice participated in some discussions with several individuals across the United States as well as the UK and Australia. And as Jason just mentioned, it is an access to justice issue. Our court saw that we just were not filling the gap, and lawyers are not doing it. And as I keep saying, every time I'm asked to speak on this subject, only lawyers could mess up economic theory. We have underemployed and unemployed lawyers, and then we have people who need legal services. So we have too much supply and too much demand. And our Supreme Court our former Chief Justice created a task force, not just to deal with the access to justice, as Jason mentioned, not just the poverty level, but middle income people. How do we get resources to them? How do we even tell them that there are legal services available that they could probably afford? But the task force also was concerned about the sustainability of the profession. What do we do about the fact that we have underemployed lawyers, we have unemployed lawyers, and how do we match them with the people who need the legal services? So the driving force was really our Supreme Court task force, a few enlightened lawyers, as well as the justices, moving this forward, and then literally brainstorming. How do we do this, and can we adapt, or do we need to throw away the whole model of regulation that we have? And so we came up with what you see out there in Arizona now.
I guess, Linda, that, just to underscore a point that you made there, there is that need that both you and Jason have referred to, which is obvious, palpable, and visible. But there is that huge hidden need, which could really exacerbate in a way that we're not even fully conscious of the A to J issue, right? I mean, the folks who don't know what they don't know, and therefore they don't know that they need to access a lawyer before it's almost too late. So the problem that I guess has been driving you could be, in fact, much bigger than we all imagine. Yeah, fantastic.
Absolutely.
And John, if memory serves me correctly, this kind of leadership from the courts, the Supreme Court, has been something that's been very much front and centre in one of your drivers, I guess, or the drivers behind the drivers for regulatory reform.
Absolutely, I think it's a given that Justice Dino Himonas is a force of nature when it comes to the enthusiasm that he brings to this particular initiative. But he's really, and we are really motivated by the same very points that Jason and Linda have made. To me, I believe the courts are starting to realize much more than maybe they did. Their role as the regulator is not to serve the benefit of the lawyers. It's to provide a system that ultimately delivers affordable legal services to the population as a whole. And that's been a realization. And I think people come to that different ways, and they have different abilities to accommodate it. But I imagine you were the one regulating barbers, and the people came and said, only 15 out of 100 people can get a haircut. And we need to figure out a way to change the way barbering is regulated so that there's actually an opportunity for everyone who needs a haircut to get one. And that's the kind of systemic change that really we're talking about when we talk about regulatory reform. The only other thing I'd add is I think there's a piece here about globalization, about, the world is flat. The access to information is much more there. Some of the things that have made sense for centuries about the way we provide legal services really don't make sense anymore. I can look up the law. I'm not sure I practice law in New Zealand off the books, but I can look up the law in New Zealand from over here in Utah and have access to information that I never had before. And I think that's another big picture driver behind a lot of this.
Yeah, absolutely. But, and just a couple of points that I want to pick up there. I think that, and really coming out of both what you and Linda said, that I guess we've traditionally seen the courts as being very conservative, judges or justices being very conservative, and not really the thought leaders in or taking that thought leadership role. And in the work that you are both doing in this area, we've very much seen that flipped, with the court really taking a front and centre thought leadership role, which is obviously absolutely amazing. But the other thing that I'm struck by and what you said, John, in fact, what all of you have said so far, is it seems to me there's been a little bit of a mindset shift in all of this as well, about taking, if you like, the law to the, instead of taking the people to the law, taking the law to the people, or the people to the courts, but the courts to the people. And I think I'm reflecting commentary there really that's been offered by Jordan Furlong. But to me, that's been one of the most critical mindset shifts for us in this reform, that it's not about the lawyers, as you say, John, it's about the folks that need access, and it's not about what's convenient, perhaps most importantly for lawyers, but what actually enhances access. With all of those thoughts, Jenny, and on this question, can you wrap us up on these drivers for regulatory reform?
Yeah, look, I'd have to, I'm very interested hearing this, because I feel that in Australia, the thing that we've been really focusing on is getting all the states under the same regulatory regime, so the uniform law efforts. And unfortunately, that has really obscured the very important issues that my colleagues have just discussed, which is the fact that you can, the reforms that we have made, we still have that access to justice problem, and there's a lot of different factors involved in it. So just this morning I was reviewing an article by Becky Sandifer on it's really on the question of what do we actually need to know about this. And one of the comments that she makes is that you can quote that 80% of people don't get access to services, but how many of those problems are actually, I don't know how to pronounce this, justicable, I think is, how many of those problems are actually problems where you need a lawyer and you can't sort them out for yourself? And also, the point was made that you don't know what you don't know, that there's a lot of legal problems that people don't think of consulting a lawyer about. So there's a whole lot of really fundamental questions that we need to go back to, not least of which is what role do lawyers actually play in the legal system? And the way that I'm, not that there's any sort of necessary reforms going in this direction, but I'm thinking we really need to look at regulating legal services rather than regulating lawyers. Too much regulation is about lawyers and law firms. But we need to think about regulating legal services and also, I think, regulating legal services as a consumer good. So looking at them as consumer services and consumer goods rather than looking at the profession that provides them. But that's kind of blue sky thinking.
Yeah, but I want to get into them, because I think that we are seeing some differences there in terms of, say, the UK and how they and John, I know that you folks in Utah have been chatting on and off with them as well, but kind of seeing it almost, if I may express it this way, the need for a systemic rethink, whether it's systemic change, I think may well be the case, it may or may not, but certainly a systemic rethink as opposed to tweaking at the edges or even just pulling out a particular thing to look at. And I guess, again, as we look at the UK, they spent some time going through that process of doing a pretty major systemic review before they came out with a whole bunch of different stuff at the other end. So before kind of jumping into some of the detail, and I do, about, what in particular the focus of regulation may have been, can I ask all of you that question of, are we ultimately looking at a systemic rethink, or are we okay with choosing pieces and almost evolving change through that? And Jason, can I throw that question to you first of all?
Sure. I think I would think about it in two ways. I think we do need a systemic rethink when it comes to regulation and the regulators. And I think, Jenny put the point quite nicely. I thought we need to really think about regulating legal services and not regulating lawyers. And that is just such a huge shift for courts, for state bars. And so I think that's really, and then the question of how we regulate. And what we look at, and of course, that's what John and others are exploring in Utah with their kind of risk-based regulation. So I think that's really where we need the most systematic rethink. I think in terms of legal services, that's where I think we can be more incremental and say, okay, lawyers, you're doing what you're doing. You're serving clients in particular ways. You're making money in particular ways. Hey, here's some other ideas. Here are some new business models that you might try, and maybe you're not permitted to try right now under the current rules. But if we change the rules a bit, you may be able to experiment with some different business models that might bring you more clients, bring you more customers, bring in additional revenue streams. And that's, I think that's what we're seeing with some of the one-to-many products that we see both in the market that serves individuals and small businesses, and even in the market that serves sort of mid-sized and larger businesses. So anyway, that would be my take on systematic rethink.
Yeah. And Linda and John, just kind of staying at that kind of 40,000 foot level at the moment, systemic change or evolving, jumping through various bits and joining them together. And what do you think about that, John? You're smiling, so I'm going to you.
I was trying to figure out if I was going to get a chance to hear Linda first, but that's fine. Here's what two things. One, I think there's a reason this is starting in the Mountain West. I think it's the reason it's starting in the Western U.S. And I think I don't know what you mean exactly by systemic rethink, but what I think is there's a person somewhere in their garage tinkering with some solution to some legal problem that is going to drive a new way of thinking without really, frankly, waiting for the regulators and the systems to all kind of reset and study things nicely. And in that way, it's going to be a much more organic process than maybe anyone can imagine. And the other element of that, I think, that is partly, you say what's driving, we asked about what's driving this. We had scooters show up on the streets in Salt Lake City, just like Uber showed up in the streets in New York City without waiting for permission from the regulators. Yeah. And that's just where the world is going. And that same dynamic, I think, is present in legal services. And we've called it for years UPL, and we've tried to kind of say these people can't do these things, but the market pressures are just really strong around those types of new innovations, and people need help, and they're going to go where they go. So I think it's more that type of thing which will drive kind of a restart about how the system needs to operate than us redesigning the system at the front end.
Okay, Linda, tell us what you think.
Oh, that's a very scary open-ended question, Terry, but leaving it only to the regulation of the profession, I agree with what's been said, and it's interesting, John, that you mentioned the Wild West in the United States, because sometimes I think, and Jason, you have my sympathies. I think it's sometimes okay to be from a smaller state, because our Supreme Court went out there and started reviewing stuff. They pulled in a few experts in each area and said, we need to do this. And actually, Arizona did that back in 2003 when our court approved document preparers. And that was, oh my gosh, that was shocking. We're going to allow people who are certified to prepare legal documents? And the answer was, you know what? they're already doing it, and they're doing it poorly because they're not regulated at all. There's no accountability. And our court said, all right, let's set some standards and let's make them accountable. Let's make sure they're competent, but people need these services. And our court went for it. And at that point, we heard it's the end of the civilized world. Lawyers will be out of business. And guess what? They're not.
Yeah.
There's still legal needs out there. But the one thing I wanted to follow up on Jenny's point on uniformity, because that's something, and John's point on flattening the world, Arizona, we have these changes. Well, we're getting calls, and John, I assume you're getting inquiries from outside of our state. And the problem is, if I have a lawyer sitting in California who wants to own one of these new ABS entities in Arizona, not going to work because California doesn't allow fee sharing with non-lawyers.
Mm.
So uniformity and getting at least some US states on board with having some more flexibility and some more innovation would be helpful.
So I'm just going to say these words and quickly move on to the next item, which is the globalization of the legal profession is probably not that far down the track. If we think about kind of the natural flow of where we're going, so beyond even uniformity within a country, but basically the ability to move with more fluidity and mobility between countries. Jenny's shaking her head. Don't like that idea?
No, it's not that I don't like the idea. I just think it depends on what segment of the market you're talking to. I think there is actually a really big difference between the large-scale commercial law and the mum and dad consumer matter legal matters. So I think I loved what John was saying about the tinkerer in their garage. I have a very romantic view of entrepreneurs sometimes, I think, but I love the idea that somebody can come up with something a bit wild and unusual that changes the world. So just recently read this wonderful book called How Innovation Works by Matt Ridley, and it's just full of those stories, and it's just, it's an exhilarating read. But that being aside, I think, say, for example, if you take a book like Gillian Hadfield's Rules for a Flat World, if there's still going to be, large-scale international trade, you need to have a different kind of system that accommodates those kinds of standards and I guess has enough wriggle room to get everybody on the same page about how their contract works, how their supply chain works. So basically a set of rules that would apply to a large-scale international commercial transaction like that. But cultural norms remain extremely important at the local level and at the social level. So most of the issues that affect the mum and dad consumers are things like small business, family law, criminal law, consumer law, employment, and a lot of those have very culturally based indicators to them. So I think that there's a lot of scope for the local lawyer to enjoy a real resurgence, supplemented by technology and enabled by technology. But it's a very different market segment to the large-scale commercial firms, and I don't think you should have a one-size-fits-all regulatory regime for the two of them. I mean, I think there need to be common principles, which is one of the reasons why I'm so attracted to principles of consumer protection like access, information, choice, quality, safety, fairness, representation and redress. If you take those sorts of standards and apply them to any kind of law, they're broad principles that can apply, but when you drill down to the particular market, the way that they'd be applied would look different.
Thank you for that. Folks, I want to drill down into a couple of things in relation to where regulatory reform has focused, for better or for worse. And it seems, again, if we stand at this kind of 40,000-foot view, that there are two things that keep recurring, and we've mentioned both of them already. One of them is this issue around lawyer versus non-lawyer, and in using that term, I might say I really dislike the term non-lawyer, but as it is used, I will use it in this context. Ownership of law firms, so that kind of thing that we've already touched on, and the second one being, which is the point that I think Jenny was also just focusing on, which is, you know, who can provide legal services, but all of you have obviously mentioned that. So I probably want to deal with the first one relatively quickly and get into a little bit more detail if we can in the second. But John, just first going to you on this one, what are the issues that seem to be engaging people the most? And I guess there's the pros and the cons around this issue of lawyer versus non-lawyer ownership of law firms. Why is it such a big deal, do you think?
Well, I think it's a big deal at a couple different levels. First of all, that element is of the way most legal services are regulated right now is the most constraining thing. The idea that everybody, even in DC where there is such a thing as having other lawyers and non-lawyers involved, the idea that everybody who owns the business has to be a lawyer writes out, you know, other professionals as being part of that business entity. It writes out even just people as simple as a marketing professional or an IT person or someone else who could contribute, you know, benefit to the overall organization by having them included. So it is primarily an economic rule for lawyers. It is probably rooted, I think, in some sense that if people other than lawyers are controlling the entity that's providing the legal services, that there's going to be an undermining of the quality or the integrity of the legal services in some way. But that's partly what we're testing, right? Is to see if that's really so. So I think that's the big picture there. There is, in my mind, as I've seen these things unfold, there's a wide range of what that means. We have one applicant who just wanted to give a 10% ownership of the firm to a paralegal in order to retain the paralegal. That doesn't seem all that controversial, but still nevertheless prohibited. We have others that have really the line between non-lawyer ownership and then fee sharing and referral fees is all kind of an economic spectrum there as to where things are. And I would say there is a lot of money, there's a lot of interest, let's put it that way, in how the business may be getting to the lawyer that is playing into this, the marketing, if you will, the promotion of the legal services. So, and then the last piece of it is this sense that the big accounting firms are going to come in because they're going to be the ones that own and control the provision of legal services, and that's going to sort of undermine the entire profession as we know it.
Yeah. Thank you for that. Linda, I wanted to pick up on one thing there, and particularly if I may draw on your background as an ethics lawyer, because this issue around lawyer and non-lawyer ownership, you know, one of the things that's often underscored is the issue around ethics. How are you seeing that play out in this discussion, and more broadly, any other thoughts you might have on what John has just said as well?
Well, at least in Arizona, and I agree with John's points and how we're seeing this in Arizona play out. What I fondly refer to, and truly with all fondness, the pitchfork crowd, which are our lawyers who thought it was the end of the world if we allow evil non-lawyers to have ownership interest in firms. And I'm hoping that it's not just because it's only an economic issue or an ego issue that only lawyers can control a law firm, because realistically, anybody in a big firm already, your firm administrator is controlling the firm anyway. But that aside, really what we're seeing now is if you put some safeguards in place, the concern that a non-lawyer will only be worried about the bottom line. They'll be worried about how can we make the biggest profit with the least amount of cost. So we're going to cut corners, and we're going to upcharge clients, and we're going to upsell clients. And really putting some safeguards in place. And it's kind of interesting. Utah's gone one way in opening up this sandbox, and Arizona, I think, has gone a little bit of a different way in trying to safeguard what we thought were realistic and very legitimate concerns for clients. All right, we'll put some regulations in the ethics rules that we're eliminating that rule about, okay, we'll have non-lawyer partners, but we're going to have a compliance lawyer. And that compliance lawyer is going to have to do certain things in the firm to make sure that nobody controls a lawyer's independent professional judgment.
And that's been something unique that Arizona has done, if I may just mention that as well, to kind of require that that lawyer involvement. Is that a fair comment?
Yes. Yeah. Absolutely. And that's not to appease the pitchfork crowd. It's literally to assure that nobody's going to tell me how I represent clients. I have to decide that.
Yeah, absolutely. I wanted to.
Sorry, can I just pop in and say that is actually covered by the uniform law. So if you've got so the uniform law that we have in Victoria, you can have non-legal directors and partners in incorporated legal practices, but the person who's responsible for the ethical compliance of the firm is the lawyer director. So you have to have somebody who where the buck stops.
Yeah, thank you. Thank you for that. Jason, I wanted to come to you next because I wanted to pick up something that you were saying before, but I would quite like to get all of your thoughts in relation to this as well. And that's on this kind of second issue of who can provide legal services. And I think when you were chatting before, you were kind of talking about this combination in a way of perhaps self-help that could be tech-enabled and paralegals. And I want to come to you particularly in relation to that, Linda, and what you're doing in Arizona, and lawyers as well. And it seems if we somehow unbundle the services and re-aggregate them in a way where all of that could be part of the mixture, that might work. So how is that right? And how do we work out the balance in a way in all of those bits and pieces?
Yeah, great. So I think, if we think first about the current problem with why so many are priced out of the legal services market, both individuals and small businesses, it's because we have this model of one-to-one services where an individual or a small business is talking to and getting lawyers' time and paying for that time by the hour. And when lawyers' fees start at, $200 an hour and up from there, any kind of middle income individuals or small businesses are just not going to pay for that. They can't pay for that. So the question is, how do we, as you put it, use both people and process and technology to create, what are these really one-to-many as opposed to one-to-one products and services where you can really package lawyers' expertise and deliver that to consumers, deliver that to clients in a way that's more affordable. Now, we have examples of that, but there are limits that the regulations impose. So let me give you a quick example from here in the Bay Area. So there's a woman, who started as a solo practitioner, family lawyer in the East Bay here called Erin Levine. And she's built this service called Hello Divorce. So it's a platform that delivers at different rates services for individuals as they go through the divorce. So they can, first of all, get free access to her platform and get some basic information that they can use to go through a divorce. Then they can pay on a subscription basis, a monthly rate, to get access to legal document preparers. Because here in California, in addition to Arizona, we have legal document preparers as well. And so they can answer some of the basic questions. Then if they pay a bit of a higher rate, they can get access to an expert system through the platform that can walk them through, and then access to a lawyer for some of their questions. And so this is an example of a way that, this is not Facebook or Google creating this. This is an individual solo practitioner, family lawyer in the Bay Area who started this as a way of making her own life and the lives of her colleagues more sustainable and bringing in revenue at the same time. It relies on paraprofessionals. It relies on technology. But when Erin Levine started this company, and she said this, she managed to make it across the finish line. But as anyone knows who knows about the life of an entrepreneur, and I'm married to an entrepreneur, like, it's a tough race. It's a tough marathon. And a lot of people don't get there. And people like Erin Levine have the limits that regulations place on them as a ball and chain that prevents them from getting across the finish line. So many don't make it the way she did. And those regulations are specifically a lack of additional kinds of paraprofessionals that may not make as much or charge as much as a lawyer, but can answer a lot of the legal work, right? What we have now in legal services, certainly in the US and in most places, is a situation as if in the medical profession, there were just surgeons, and then there were the people who work at the reception desk when you go into a doctor's offices, right? So it's the way the medical profession was 50 or 70 years ago. But no, in the medical profession, they created nurse practitioners, created physician assistants to be able to really deliver those services in a more comprehensive and affordable way. And then I'll just wrap up by saying the other big ball and chain on entrepreneurs like Erin Levine is the inability to raise capital from people who are not lawyers. And so there are many potential investors who would have been glad to invest in such a consumer-facing business, but cannot. And that's just a big limit we put on entrepreneurs. And I think if we just overcome these limits and experiment with relaxing these limits the way we're doing in Utah and Arizona, we can really make a difference in bringing more of these one-to-many products to consumers who need the help.
Thanks, Jason. And I want to pick up on a couple of points there with you, Linda and John in particular, if I may. Linda, kind of in relation to the role of paraprofessionals and how you've kind of embraced that and working with it in quite a different way. And John, I want to come to you after that, if I may, and just get you to tell us a little bit about the regulatory sandbox in Utah. Because it is one of its kind, not hopefully not the only one, but something that I think is certainly worth us having a chat about. So, Linda, first with you, if I may, because Arizona has really taken quite but still somewhat unique stand about the role of paraprofessionals. Tell us a little bit about that.
Well, we've had, as I mentioned, since 2003, document preparers. And that was supposed to fill a gap of at least providing documents to folks who needed it. And it really has. It has helped tremendously. And I'll talk about legal paraprofessionals in a second, but the part I still don't get is, and Jason, this goes back to one of your points, something called unbundled legal services. It's a catchphrase. And it means, okay, the lawyer's not going to do everything for somebody. They're only going to do one demand letter. They're only going to review a document for somebody. And try as we might, I've only been doing this for 27 years. We still can't get lawyers to understand that they do that all the time and could make their services more affordable. So that also comes in the context of litigation, where somebody believes they have a small claim matter, something that's not going to require extensive briefing. It's not going to have a huge 6-month-long trial. Our court adopted regulations to have legal paraprofessionals. And again, with the two standards, competent and accountable. So they have to have educational background, they have to take an exam, but they will be allowed to function either in a firm with lawyers and non-lawyers or on their own. And they will be going into court. So it will be the next level. We have document preparers, and then we have the legal paraprofessionals who will be going into family law matters, some low-level criminal matters that don't involve incarceration, some administrative proceedings, and some small claims matters to hopefully reduce the price that consumers would have to pay to have somebody actually help them in a court proceeding.
And I think it does kind of speak to one of the many things that Jason was chatting about as well, where, we're now conceiving legal services at different levels of complexity, but along with that, different levels in terms of a price. and who can provide that best, which leads me directly to you, John, I have to say. You folks in Utah have set up your regulatory sandbox and I guess really become a leader, not just in the country, but in many respects around the world in what you're doing. So I was wondering if you could take just a few minutes with us now to tell us about it. How does it work and how long is it going to be and who's doing what and what are you doing there in Utah with this sandbox?
First of all, if you haven't seen it, you should Google Crazy Man Dancing as a form of leadership, and you should just internalize this idea that one fool gets up in the middle of a concert and starts dancing like a crazy person. And it takes a while before a bunch of other people kind of decide they should join them. And then soon enough, the whole group's up and having a great dance. So we do feel a little bit like we're the crazy man dancing, but we have essentially created a structure where there were some rule changes so that essentially now anyone can provide legal services. But in order to seek the right to pursue legal services, they need to come to our office, our sandbox office, and they need to present a proposal. And these proposals, have variations on themes. They could be non-lawyers partnered with lawyers. They could be lawyers partnered with accountants. It could be it's really kind of a open agenda how someone may choose to structure it. Non-lawyers could provide legal services. Non-lawyers could have ownership interests. All of those things are possible, but they're only possible in our sandbox. And that means they make a proposal. We evaluate it. I could go on a long time about how we do the evaluations, but I'll skip that step at the moment. And then we recommend to the court that this particular applicant be authorized. And when we make that recommendation, we're essentially authorizing them for a limited period, primarily a 24-month period, to do this thing that they say they'd like to do, to provide legal services, and they have some strings attached. And those are important. Those are critical, because while we allow anyone to do it, if it seems like an appropriate model, it's only if they supply data to us on a regular basis about what's going on with the model. And it's a pretty robust set of data that they must provide. Lawyers don't provide any data to the regulator on what they do with their licenses. This is a pretty long list of data. It's only if they provide certain disclosures, things that say stuff like, this is not a law firm. This might not be the same as what you get from a law firm. So there's disclosure requirements. And then some of these data testing requirements would include, for example, in some instances, let's take a non-lawyer computer-driven algorithm that's providing some type of advice about estate planning or whatever it is. Well, one of our tools is to require expert review of the first 20 instances of that. So the first 20 times that they go through that process, they need to have a person who knows estate planning, a lawyer who knows estate planning, look at the outcomes and give us data on whether those outcomes are appropriate or not. So that's the basic workings of it. Is they make an application, they get approval from the court, and then they're watched, and we regulate them actively with this data collection. And we're going to find out. We're going to find out if these things are causing harm to consumers. We're going to gather the data that we think are pertinent to whether there is indeed harm being caused to consumers by these other models. That's it in a nutshell.
And John, thank you for that. So if I'm understanding you correctly, the kind of the overriding or really big picture thing that you're focused on here is risk, is the concern that the harm may or may hopefully will not be done. Is that fair, or is there other kind of that you would put in that category, those kind of big picture things that you're kind of looking particularly to manage and monitor?
We've tried to not have a lot of ex-ante regulation about who can and can't be in here. We've decided we can't have felons and we can't have disbarred lawyers, participating, at least with any control. But past that, the real question is, what is the potential that this is going to cause harm to consumers? And we've identified three basic types of harm that could happen. One that Linda alluded to earlier was that they could be upsold. They could be sold a legal service they don't really need. Another is that they could get wrong or bad legal advice from this particular model. And the third is that they could just fail to exercise some legal right, that something would be overlooked. But critically, and this goes to the access to justice point, the standard there is not relative to a lawyer that you're paying $200-300 an hour with an unlimited budget to get that same service from, because that's not essentially not what the alternative is. The alternative is, in most cases, self-help, DIY, not something that really is professional advice at all. So that's our gauge for whether it's causing harm.
Yeah. Thank you for that. Jason, we've struggled for a long time in Australia, and I want to get your thoughts on this as well, Jenny and Linda, with this almost artificial division between we'll regulate lawyers who are giving legal advice, but we won't regulate anybody who is providing information. And in the sort of scenarios that John has just described, and you've all kind of alluded to, it's not just the blurring of that, it's actually there is no division between those things. And increasingly with technology as well. So I'm wondering, Jason, listening to John, what comes to mind? Because I know you folks in California are looking at the regulatory sandbox idea as well. What kind of struck you around those big picture issues for people to be thinking about, perhaps your jurisdiction thinking about, in terms of setting up its own regulatory sandbox?
Yeah, I mean, I think your point about the distinction between legal advice and legal information is a good one. And it relates to something that John was talking about earlier, about the fact that there is this whole unregulated world of the provision of things which look and sound a lot like legal services. And so if you're talking about whether it's LegalZoom or Rocket Lawyer or, apps of various kinds, there are people out there who are just sort of right around the line of the unauthorized practice of law. But there's no check on them in terms of any kind of risk of consumer harm. So I think the basic idea is, why don't we just have sort of a broad conception of legal services and allow sort of more people and more entities under that broad umbrella, and then regulate them all in the same way. And so I think that that is sort of where this is all headed, and where I hope things head in California.
Do you hope that they head that way in Arizona, Linda? What are your thoughts about that?
I think we think we're already working that way. And I guess my suggestion, my concern for lawyers, since I advise a lot of lawyers, I wouldn't use the words access to justice. And I know that's heresy in most circles, but lawyers hear that, they don't hear access to justice. They hear, you want me to give away more free stuff and you're going to put me out of business. So I try to encourage lawyers to understand the opportunities, embrace this as, we're not adopting LPs, legal paraprofessionals, to go into court to put you out of business. Hire them. They can provide more volume and go back to, and I think our court already is at the point where it's looking at regulating who provides legal services, or regulates the legal services and not just who it is. So making sure that when you're going out there and you're trying to do these innovations, make sure that you don't just say, well, it's access to justice. We all have, and our court can do that because that is their mantra. They are there to actually make sure that there are services for everybody. But I see this as an opportunity for traditional law firms and the person in their garage and the person on the internet providing the services in some way, maybe together.
And I guess, to go to a point that all of you have made, and thank you for that, is that even if we've got the numbers wrong, even if there's less than 80% of people with a legal problem that don't approach a practitioner, there's still 80% of people looking for legal solutions. And at the moment, we're kind of somewhat arguing about the 15 or 20%. There's a huge thing. And I'm not sure that any nurse practitioner has actually put a doctor out of business. So, I mean, there's other industries that we can look to in relation to that as well. Sadly, I have to start to wrap up. And I do say sadly because it's been a fantastic discussion. But I wanted to do that by coming to you with kind of your thoughts, your words of wisdom and advice, given where you are at different stages, but also obviously being quite reflective and very thoughtful about all of this. And that is, if there's somebody listening today who would like to influence, propose, or perhaps even in the middle of thinking about regulatory reform of the nature we've spoken about today, what advice would you give them? One piece of advice would you give them? The top piece of advice that you would give them in terms of advancing that? And Jenny, I wanted to address that question to you first.
Thanks, Terry. Yeah, look, I think my top piece of advice would be get a grip on the reality of the legal services market and get a grip on the reality of what people actually think they're buying when they retain a lawyer, and also what actually are the problems that they could be that do have a legal aspect to them where they could be assisted. I think Jason made the point, and I've seen it. I've seen that also. I don't know if it was you that wrote the Legal Evolution blog, Jason, about that full range of services that you get provided by various different professionals and paraprofessionals in the medical field. I don't think we have a big enough grip on what are the problems that people are actually facing where they can be helped. And there's a certain proportion up one end of the market which are definitely the problems that trained lawyers can help people with. But there's a whole bunch of other stuff. And, you know, lawyers are such noisy, opinionated persons that they tend to portray their end of the market as being the only market, whereas there's just so much more out there, and there's so many more services that could be provided if we had a lot more visibility on what people need and want. So I'm really curious about all sorts of things about how does the legal business work? What do consumers actually want and need? Where are the unexplored and underserviced areas of the market that people could really start concentrating on? So I think outside the box, adopt an innovator's mindset, and think about just putting in place some strictures that will tell you what's the final result that we want to have. We want people to have accessible services. They need to be safe. They need to be fair. They need to know what they're buying. So if you put in place those strictures about the end result that you want, but then leave plenty of room for people to experiment and keep an eye on things so you can actually step in and prevent harms from happening. I think that's probably what we really want. We want to see what will actually help innovation to happen.
Terrific. Thank you very much. Jason, your one piece of advice?
It's two, but they're closely related.
That's all right.
That people thinking about regulatory reform are clear and concrete, both about the people who might be helped by these reforms. I think particularly now, as we've seen with the COVID crisis, it's shined a light on people who are essential workers, nurses, people who work at grocery stores, middle-income people who can pay something for legal services, but just can't pay the kind of $200 an hour or up that's typical. And on the other side of that, the small businesses, restaurants, nail salons, people like that who also need help. On the other side of the equation, I think we need to be clear and concrete about what those solutions are going to look like. I mean, that's why I talked about Erin Levine's Hello Divorce platform that uses technology, that uses paraprofessionals, and that use lawyers' expertise together to deliver a kind of affordable solutions for people who are just currently not getting legal services at all.
Yeah, absolutely. John, your thoughts, your closing thoughts on advice for folks that are thinking about all of this?
Well, first of all, I'd just like to thank you, Terry, for organizing this. It's been a great conversation. I think my number one word would be collaborate, because I think there is a lot of discussion going on around these issues, and there are norms, to be developed. And it goes to Jason's point about having clarity around things. It's trial and error, but it's a learning process. And the more people who are involved in it, we post all of our stuff on our Utah Regulatory Sandbox website, including our manual for how the Innovation Office, assesses risk. And we don't claim that it's the right answer, but it's at least an approach, and feedback from that. And the Center for Legal Profession that Jason directs, and the Institute for the Advancement of the American Legal System at the University of Denver, all the other states that are participating, all of those, I think, are resources. And we're all sort of collectively trying to address the same problem and find similar solutions for the same issues out there in our community. So that's what I'd say is team up.
Yeah, John, look, you're speaking something, I guess, preaching to the choir for us at the centre, because we see these solutions as being global. And it's why with these sort of sessions, and we've just been delighted to be able to host you today, we see it as so important to bring the thought leaders yourselves from around the world together, as opposed to just kind of, focusing on a particular state. So thank you for that. Collaboration is near and dear to our heart. Linda, you have the very last thought and piece of advice to end us on today.
Don't panic. Yeah, seriously. There's so many opportunities out there. When you hear things, think about it. Think about how it might work or how you could even improve it. And don't just shut down and say, no, we can't do that. Think of the opportunities, embrace the opportunities. And if you're a regulator, make everybody think it was their idea.
Yeah. And on that note, and with all of those fabulous ideas, thank you so much. Really appreciated having you here today. Jenny, John, Jason, Linda, just absolutely delighted. And for folks that were here, thank you for your kind feedback as we've gone through this, and thank you also for your participation. We will be back with lots more sessions next year. This does close us out for this year, but do follow us on LinkedIn, Facebook and Twitter for those upcoming events. To all of you, all of our panelists and all of you listening here today, and all of you who will pick this up or listen to it later, our very best wishes to you and your family for a restful, peaceful and joyful holiday season. Thank you very much, folks. Until next time.
Thank you.